Hello and welcome to The Big Fight. Now, it's not that often that a 9-judge constitution bench of the Supreme Court sits down to try and get a view on something of importance to all of us. And that's really what's happening right now. The Supreme Court is sitting to take a look at the right to privacy. Now, it's really coming up more and more in connection with Aadhaar and the various questions around Aadhaar and whether it should be heard by a 2-judge bench or a 3-judge bench. But the right to privacy is something that affects each and every one of us. And that's true today. It's going to be even more true 5 years later. And as digital technologies and technology continues to spread, that question will keep coming back and back. In fact, it's almost surprising that the Supreme Court has not had to constitute a large bench to look at this, because some of the earlier verdicts on the question of whether privacy is actually a fundamental right date back to 1954 and 1962, and obviously the entire world has changed since then. So we've got one of the most illustrious panels I can think of who've done, each of them has done a lot of work in this area on the right to privacy in particular, whether it should be a fundamental right, what it means for other schemes like Aadhaar and elsewhere. What happens, the other question that came up in the Supreme Court, what happens when individual companies are taking people's data and then making that public? What should be done with that? What happens when there's data you're giving to WhatsApp? What should happen to that? So lots of questions to really discuss out here. And let me start by welcoming Mr. Shailesh Gandhi, former Central Information Commissioner. It's a pleasure, sir, to have you with us. Here in the studio, we've got Vikas Singh, Senior Advocate of the Supreme Court. Abhijit Dwivedi is spokesperson of the ABVP, but has been taking a close look at the entire issue. Also has a very strong views on Aadhaar. It's a absolute pleasure and a privilege to have my friend Ashwini Kumar back with us. Of course, Minister, Senior Congress Leader, and also Senior Advocate of the Supreme Court. So I did say we have lots of legal luminaries here, because standing next to him, another Senior Advocate, Mr. Vikramjit Banerjee, a Senior Advocate Supreme Court, also BJP Legal Department. So great to have all of you with us. And two special guests now whom I want to welcome onto the program. Soli Sorabji, of course, one of the country's most distinguished legal minds, former Attorney General of the country, also in this case advising and a counsel for one of the petitioners arguing for privacy being a fundamental right. So, Mr. Sorabji, thank you so much for being with us. But before I come to any of you, I want to quickly go to somebody who's then going to have to leave us. Shankar Iyer, written a book on Aadhaar, written about also Accidental India. Is privacy a fundamental right? Is it something that should be treated as a fundamental right? And how does it affect the entire question of Aadhaar itself?
Well, I define this in the following way. Privacy is a natural right because democracy functions on the construct of personhood on free will. So as far as that right is to be protected, privacy is to be protected. But privacy will function in a moving context in the sense that technology, politics, all of it dictate the contours of privacy. And so there is bound to be limitations on the real definition of privacy, and this will move fluidly as the context changes. In 1974, post-Watergate, the US government passed the privacy law. When 9/11 happened, they passed the Patriot Law, where people ceded much of the rights to privacy. And then again in 2012, after the Obama regime sort of diluted the Patriot Act, came the Freedom Act. So the idea of privacy is inversely and interminably linked with the idea of security. In thus far, I think the dictation would be privacy would have to bow to the issue of personal security. So privacy
you're saying
is
it is something that
definition.
keeps moving back and forth, which is true. Although in the US, the Fourth Amendment, by and large, has survived the test of time, which means you can't just go into somebody's house, you can't just take away assets. There are Fourth Amendment protections out there. Before you leave us, I wanted to get your take on Aadhaar. How crucial is the question of privacy to Aadhaar, which is obviously something which you've written extensively on?
Really speaking, Aadhaar holds only the demographic and biometric data. So when people say that Aadhaar can be used to snoop on individuals, the law doesn't quite allow that just now. The bank knows your bank account number and the Aadhaar number. The Aadhaar depository does not know your bank account number. The income tax department knows your bank account number, your PAN card number and your Aadhaar number. But the Aadhaar depository does not know the other details. There are far easier options available starting with your smartphone and connectivity. But Aadhaar needs to be protected with the data protection law, because today if your data is leaked or lost, you don't really know where to go. The current Aadhaar Act, the 2016 Act, says that the UIDI will file a case and fight on your behalf. Really, justice demands that individuals be given the right to fight their cause. Second part, privacy and data protection go together. One cannot be achieved without the other. So the government has to move forward and bring in a robust law on data protection, on real-time disclosure of data leakage and real-time redressal of grievances, so privacy is protected.
All right, Shankar. Well, thanks for joining us with that perspective, helping set the stage for what we need to talk about. Mr. Soni Sarabji, if I could now turn to you and the Constitution bench itself. This is not the first time that the Supreme Court has actually looked at the question of whether privacy is a fundamental right or not. In both 1954 and in 1962, the Supreme Court, not a 9-judge bench, but fairly large benches of the Supreme Court, actually did come in and say that no, privacy is not a fundamental right. If you feel that that needs to be overturned today, what's the reason for that?
Well, actually in 1954, the issue didn't actually arise. But there is an observation of the Supreme Court which suggests that privacy is not a fundamental right. Then again in 62, the issue didn't arise in the present form. After all, Vikram, please remember, essence of the right to privacy is the right to be let alone. We don't want the government to know what we ate, what we drank, what films we see at home. That's the essence of it. You can't. Privacy is a right which inheres in every human being by virtue of the fact that he or she is a human being. So the question is, the larger bench is considering what the 9-judge bench, to what extent those judgments are correct, are they merely obiter dicta, and if they are correct, do they require to be revisited, or in other words, to reverse. Now that's the thing going on. It's sub judice. I don't want to say more. I'm appearing in the court, but I'd like to say, please remember that privacy, no one claims, is an absolute right. It cannot be. No fundamental right is absolute. But then there should be reasonable restrictions. They can't be just blanket restrictions. So that's the whole thing. That's the balance that will be struck between the right of privacy and the right of the society, or the interest of security and other things, to some extent override that right, which I said is not absolute, like any fundamental right in the Constitution is not absolute. It's subject to reasonable restrictions.
But again, the Supreme Court said it. This is an important question to settle. It's being linked with Aadhaar, but it has other implications. I mean, I think whatever happens here may well decide other cases. Well, NAS, for example, the criminalization of gay sex. Those are some of the questions that can also end up getting linked to the question of whether privacy is a fundamental right or not. What is your take on this? Because fundamental rights are sometimes extrapolated, and I think that's what some of the petitioners seem to be saying. It may not be stated in the Constitution, right to privacy, but sometimes you extrapolate. Like the freedom of press is extrapolated from the freedom of speech.
So no one denies right at the beginning that you have a right to privacy. The question is whether you make that right to privacy into a fundamental right. Because if anyone who knows constitutional law and who's read recent constitutional law will know that Supreme Court has in Coelho's judgment said that fundamental rights, the essence of every separate fundamental rights, is part of basic structure in the Constitution. Which means that the moment you treat any right as a fundamental right, it gives extra protection. It's almost ring-fenced from the Constitution. And in the day and age of today, where on the one hand you have the dangers of the internet, you have the dangers of security which are increasing, whether you would give such a strong protection is something which needs to be debated, and it needs to be debated very closely.
If I understood you correctly, what you're saying is, yes, privacy needs to be protected. Privacy is a constitutional right, or can be seen as a constitutional right, which must be protected. Don't treat it as a fundamental right, because then it gets special protection over and above that, like freedom of speech and freedom of religion.
On the level of freedom of speech and freedom of speech.
Okay, somebody who's got very strong views on this, and I know you've written a lot on this, studied it extensively for years. Would you agree with what he said? Protect privacy, but don't make it a fundamental right.
Please remember, Vikram, our constitution is not only a republican charter, it is a dignitarian charter. Right to privacy as an integral adjunct of the right to dignity under Article 21, repeatedly affirmed by the court, cannot be denied as a fundamental right. It is so inherent to a human person that Justice Krishna Iyer in Menka Gandhi's case, again 7 judges bench, said, for man to be human, these rights must be synthesized in that person. Right to privacy has been treated at a much higher pedestal as right to dignity, and that right to dignity is the cornerstone of the Constitution. As somebody said, the Constitution is a sublime oration on the dignity of man. And the moment you start encroaching upon this right, which is the corner arch of our Constitution, you pave the way for the state to keep encroaching on liberties. This argument that for security we need ABCD structures are all understandable, and nobody has said that any fundamental right is absolute. But it is necessary to say beyond any ambiguity whatsoever that the right to privacy must be treated as a sacrosanct fundamental right.
Okay, I'm really hearing excellent expositions of what the issues out here. I don't think I've seen it articulated quite so clearly for a long time. I want to get everyone else to weigh in on this, because then obviously we're going to have a lot to talk about. And you can see now why the Supreme Court has a lot to think about. Both points, valid points. He says don't elevate it to a fundamental right. He says if you don't, the right to human dignity at the end of the day is the most fundamental of fundamental rights. You can't encroach on it. What is your take?
Yeah. The point is, if it is a fundamental right, or even if it is not a fundamental right.
So let's settle that issue first, and we'll come to the contours of it later.
Even if where you will see the right to privacy existing as a fundamental right, where will you extrapolate it from? Article 21. So because in Benoit Viswan, Supreme Court has said 1491 don't come into picture.
Not just 21, you can extrapolate from other clauses also. You could extrapolate it from 17, you could extrapolate it from 19.
On 14 and 19, the Supreme Court have recently, when PAN card and Aadhaar was being clubbed, on that Supreme Court has said 14 and 19 not infringed. On coming to 21, the Supreme Court, if you see that right to everybody, no one shall be deprived of his right to life and personal liberty except without a procedure established by law. What is the content of procedure established by law? So if there is a procedure, you can certainly take it. So even if you see the submission which is being made by Shyam Diwanji, in there he also says that he has quoted like UDHR, Article 12, or if he goes to the European Convention on Human Rights. Okay. So therein we see that even for the economic welfare, like European Convention on Human Rights clearly says that for the economic well-being of the community, of the country, the right to privacy can be taken. The point which Mr. Iyer has said, that whether the biometric data which is being taken from you, is it the kind of data which can be used in the way in which Foucault says that a society...
No, hang on. Let's not confuse the two issues. I'm going to come to Aadhaar in just a couple of minutes. Okay. Let's first try and establish whether there should be a right to privacy as a fundamental right. Then we have to look at whether there should be restrictions on that fundamental right, as they are in every other case. Even for freedom of religion or freedom of speech, there are always reasonable restrictions that are put on that. And third is then, how does Aadhaar kick into all of this? So I take your point. Let me just get you in, Vikas, on this.
Well, according to me, when the Constitution was being drafted, Dr. Ambedkar had suggested that privacy should be included in the fundamental right. And it was deliberated extensively and it was rejected. And it was rejected on the premise that the Constituent Assembly felt that the Parliament should make a law for this subject rather than making it a fundamental right. Unfortunately, the problem is that whatever the Constituent Assembly felt and the Constitution also envisaged, our parliamentarians are not doing that. If the Parliament had, this definitely is a right, and it needs to be a statutory right.
But a fundamental right or a constitutional right have got certain status.
That's what I'm saying. It's not a fundamental.
Which is higher than anything which Parliament will pass.
That's what I'm saying.
That's the same argument as going back to 377 that Parliament passed.
So this is not a fundamental right, because this was never meant to be a fundamental right. You can't say something to be a fundamental right which the Constitution makers very expressly considered and rejected.
Although having said that, between 1950 and 2017, a lot of time has passed. The internet didn't exist, mobile phones didn't exist, the ability to snoop on everything did not exist. Right now, given existing technology, we could be having cameras which are surveilling what everyone is doing. We could have ways of getting down information, downloading information from mobile phones of people sitting out here, they may not even know. The state can come and be present in your life in a manner which is not even conceivable.
That's why
either in 1950 or in 1954 or 1962 with the earlier times in the Supreme Court.
That's why I say that it should definitely be protected by a valid piece of legislation which will take into consideration the changing scenario which is emerging
so let the
from
court
time
put
to
this
time.
back to
Just one point. If you make it fundamental right, there are certain values, there are certain things which we can gain. Like if you make it fundamental right, in that case, if suppose something situation like emergency comes in, wherein suppose in case of how the RSS members when the emergency has came, because they had the registers and they came to know that these are the RSS members and they were taken away from home. So in that case, if right to privacy is being made a fundamental right, there are certain more layers of protection which will be available, which will not be available if a parliament makes a law. So in that
that's exactly the reason to have it as a fundamental right.
If the government is despotic, then it is helpful.
Actually, before I come in, let me just get Shailesh Gandhi and get his take on this as well, sir. The situation, we've heard some of the arguments back and forth for this. The situation today and in the modern society is obviously very different to what it was in the previous times in the Constitution. Various benches of the Supreme Court have looked at it as a fundamental right. In your view, does it need to be a fundamental right to look at all the issues that could possibly come up right now and going forward?
I think it is absolutely feasible to read life of dignity into Article 21 and therefore hold that privacy is a fundamental right. But I think with this there is a caveat. There is a lot of confusion as to what constitutes privacy, and I think we should refer to Article 19(2) of the Constitution, which says what are the restrictions that can be placed on 19(1)(a), which gives us freedom of expression, freedom to publish and right to information. What would affect only reasonable restrictions permitted in 19(2) are affecting decency and morality as far as privacy or personal things are concerned. What constitutes decency or morality is a very limited subject, and enough Supreme Court judgments have said this. Unfortunately, today, even a name is being said as intrusion on privacy. Education is supposed to be intrusion on privacy. Your fingerprints. Let's look at it objectively. Fingerprints are a part of your body, yes. Things relating to your body, things relating to your house are limits of privacy, and privacy must be protected. But where privacy ends, the right to information and freedom to publish starts. So therefore, of your body, for example, a photograph is also an identity of you. Can it be published? Can a newspaper take photograph? Can a TV camera take a picture and put it on the thing? The answer is yes.
Not everywhere. I mean, I think people will get very offended if we as a TV channel come to people's rooms or houses or bedrooms or take pictures of them brushing their teeth.
Sexual preferences, then I think it's reasonable.
Some TV channels are getting there very soon, so I probably should watch what I'm saying. But yeah, it's theoretically, it would not be accepted if somebody comes, if a TV channel comes, barges into your house and starts taking pictures. It is considered an intrusion on dignity, or it should be considered an intrusion of dignity. You know, he's got an interesting point though. Where do you draw the line? When you said the right to privacy is a right to human dignity, the question is, where is the line drawn? Your name, for example, your passport number, PAN number, if people are insisting that your PAN number should be quoted everywhere, is that a right to privacy issue? Perhaps not. One of the judges said on Friday that, yeah, look, if someone is coming in and saying, are you cohabiting with your wife? And that's obviously a privacy issue. But whether you should be quoting your PAN number every time you do a transaction, is that a privacy? Is that a dignity issue?
Look, these are specifics that a statutory law can go into. But the main question today that you are debating, and rightly so, is do we elevate the right to privacy to the level of a fundamental right? My submission was and is and will remain yes, because there's no other way you can today construe Article 21. Now, somebody said that the right to privacy was not written into the Constitution. Yes, but was the right to health written into the Constitution? Was the right to education?
But right to education,
right to environment. No.
Parliament had to pass a law to make it a right.
I'm so sorry. The Supreme Court has said right to education is a part of the right to ensuring the dignity of the man.
Yeah.
Education, environment, clean drinking water, clean air, they were never written into the Constitution. They are derivative rights.
Okay.
And all these rights, the Supreme Court has said that even Part 3 rights individually and collectively lead to right to privacy and right to dignity as a fundamental right. And you know, Constitution has principles for an expanding future. Constitution does not lay down rules for a daily conduct. Therefore, Constitution has to be construed in the light of what has happened. It is impossible, in my view, and since I'm not appearing as a counsel, it is impossible for the Supreme Court, consistent with its own jurisprudence till date, to say that privacy is not a fundamental right.
All right, Soli Sarabji, just want to come back to you, sir. Right to privacy should be different. It should be treated as a derivative right. You don't need a new constitutional amendment to be brought in. The Supreme Court should say it is inherent in what are existing fundamental rights. Would you agree with that?
I agree. And mind you, freedom of the press, is it mentioned in the Constitution? It was deduced from other articles of the Constitution and from Article 19A. So the very fact that the privacy is not mentioned explicitly in the Constitution does not mean it's not a fundamental right. Fundamental right can be deduced from other rights, as has been done in the case of freedom of the press. Where is freedom of the press mentioned? In Article 19, which gives the Charter of Fundamental Rights? No, but it is a derivative right. It can be deduced and rightly deduced from a combination of other rights. And that's what can be done, and that's and mind you, it's an evolving concept. You can't have an exhaustive list of what is privacy, what is not privacy. Depends on the context, depends on the circumstances, but the main thing is it should not disturb your right to be let alone in matters that pertain to your personal matters,
okay,
and which have no element of security or any other consideration.
Okay.